Good evening. Thank you all for braving the wet and the cold to come to the latest in our series of Mansfield's Friday Open Lectures. We're very pleased this evening to welcome one of our own and also one of our most distinguished, Judge Theodor Meron, who is a visiting fellow at the Bonavero and Mansfield College at the moment. He has a very long and distinguished career. Unlike British judges who hang up their boots, perhaps slightly reluctantly at the age of 70, but they do, Judge Meron is the Duracell bunny of judges, going on and on. He's been a judge of the appeal chamber of the International Criminal Tribunal for the former Yugoslavia, dealing with war crimes arising out of the war there, and the International Criminal Tribunal for Rwanda. And since he was elected to the ICTY, that's the Yugoslav Tribunal, in March 2001, Judge Meron has served 4 terms as the president of that tribunal. When it wound up in December 2011, he was elected a judge of the Mechanism for International Criminal Tribunals, and he's, I think, just finished serving his second term. Third term. Okay, my note's wrong. His third term as president of that. But he is also, when he's not doing that, learned in more than the legal sense of the word. He's a scholar of international humanitarian law, human rights and international criminal law, but he's also written a number of books on international law and chivalry in Shakespeare, and lots of articles, and he is currently about to embark on a professional memoir about judicial independence and his role in the international talks, in the international courts and tribunals. So this is going to be a very interesting talk. He's going to deliver it from here, and then he's going to take questions. So thank you very much, Ted.
Thank you so much, Helen. It is a real pleasure to be with all of you this evening. I expected a smaller audience given the nature of the weather today, so I'm particularly pleased to see so many of you today. I'm grateful to Helen Mansfield for moderating, and I am particularly pleased to welcome here President of the Trinity College, Hilary Boulding. Thank you for coming. Today, with some delay, we are celebrating the 70th anniversary of the adoption of the Universal Declaration of Human Rights, a document which was promulgated by the United Nations General Assembly shortly before midnight on December 10, 1948, as a common standard of achievement for all peoples and all nations. In my remarks, I would like to begin by reflecting on the significance of the Universal Declaration before moving on to discuss the impact of the Universal Declaration and the human rights revolution ignited thereby on the work of international criminal courts and tribunals. I will close by offering some thoughts on the impact of these same courts on human rights law and on the development of public international law more generally. The concept of individual rights is hardly a new idea. From the Magna Carta and the English Bill of Rights of 1689 to the 1789 French Declaration of Rights of Man and of Citizen, and the US Constitution and the Bill of Rights, there are a variety of centuries-old examples in this regard. Perhaps this fact helps to explain why, at least in part, why when the Charter of the United Nations was adopted in 1945, its cursory reference to human rights and fundamental freedoms was accepted in the absence of definitions of what those rights and freedoms might be. Yet, even the notion of individual rights was not altogether new in 1945. The adoption of the Universal Declaration some 3 years later was nevertheless a transformative event, drafted and debated within various UN committees over the span of more than a year and a half, during which everything from Confucianism to the philosopher Thomas Aquinas was discussed. The Universal Declaration reflects an effort to embody what it itself referred to as common understanding of the rights and freedoms referenced in the Charter of the United Nations. Beginning at Article 1 with the proclamation that all human beings are born free and equal in dignity and rights, the Universal Declaration proceeds to set forth rights ranging from the right to life, liberty, and security of person, to fair trial rights, and from the right to seek and enjoy asylum to the right to marry and found a family. The Declaration articulates both a range of civil and political rights, such as the right to freedom of religion, of speech, and the right not to be subjected to torture or to cruel, inhuman, or degrading treatment, and a variety of economic, social, and cultural rights, such as the right to education, the right to social security, and the right freely to participate in the cultural life of the community. The language of the Declaration is both powerful and rhetoric. It resonates to the broader public with its statement of inherent dignity, equality, and inalienability of rights. While some commentators have observed, no doubt rightly, that the final text was the result of a series of political compromises designed to ensure the Universal Declaration's ultimate widespread acceptance, this fact does not detract from the extraordinary power of the final product. Indeed, Hernan Santa Cruz of Chile, a member of the drafting subcommittee, described the adoption of the declaration in Paris, where only 8 states abstained and none voted against, as follows: "I perceived clearly that I was participating in a truly significant historic event in which a consensus had been reached as to the supreme value of the human person, a value that did not originate in the decision of a worldly power, but rather in the fact of existing, which gave rise to the inalienable right to live free from want and oppression, and to fully develop one's personality. In the Great Hall, there was an atmosphere of genuine solidarity and brotherhood among men and women from all latitudes, the like of which I have never seen again in any international setting. Of course, much of the exceptional nature of the moment can be attributed to the circumstances of the Universal Declaration's adoption, just a few short years following the end of the cataclysmic Second World War. Indeed, the Declaration itself refers to the fact that disregard and contempt for human rights have resulted in barbarous acts which have outraged the conscience of mankind. But the Universal Declaration itself was also groundbreaking in and of itself. First and most simply is the universality of the Declaration's reach. From the opening paragraph of its preamble, it makes plain that the recognition of the inherent dignity and of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world. We cannot underestimate the significance of these words for those who were, in 1948 or thereafter, seeking self-determination and independence from colonial rule and all those who were still under the yoke of cruel racial discrimination. Second, and relatedly, the declaration was revolutionary in its insistence on equality, in the enjoyment of human rights, and its adherence to the principle of non-discrimination. The terms equal or equality appear some 13 times in the declaration's short text, and the language of Article 2 leaves no room for doubt when it states, everyone is entitled to all the rights and freedoms set forth in the declaration without distinction of any kind, such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. Notably, this open-ended list of prohibited distinctions goes well beyond the more limited list set forth in the United Nations Charter, which refers only to respect for human rights and fundamental freedoms without distinction as to race, sex, language, or religion. That is for prohibited distinctions only. Third, we would be hard-pressed today to find another legal instrument as prolific in its influence and impact on the development of international, regional, and national human rights law as the Universal Declaration. We see this confirmed at the international level in the number of specialized international human rights conventions to which the Declaration gave rise, and in the fact that the more than 170 countries that participated in the United Nations World Conference on Human Rights in 1993 explicitly renewed their commitment to the purposes and principles contained in the Universal Declaration nearly a half-century after the Declaration's adoption. We see this at the regional level, where states in Africa, the Americas, and Europe have joined together in regional human rights pacts, and we see this in the scores of national jurisdictions whose constitutions, laws, and regulations either refer explicitly to the Universal Declaration or reflect, sometimes even track, provisions and principles in whole or in part. Indeed, although it was adopted as a non-binding General Assembly resolution and something that, according to Eleanor Roosevelt, who served as chair of the drafting committee, is not and does not purport to be a statement of law or legal obligations, the Universal Declaration itself has, over time, come to be broadly accepted as an authoritative interpretation of the rights and freedoms that the United Nations, as well as its member states, are bound to promote in accordance with Articles 55 and 56 of the Charter of the United Nations. I should pause in this context and note the not insubstantial academic literature concerning whether the Universal Declaration has also acquired the status of customary international law. I will not seek to wade into this debate now, though I would observe that there is a more robust consensus that at least some of the specific rights included in the Declaration have attained a customary law status, such as the right to be free from slavery, from torture, from prolonged arbitrary detention, and from other gross violations of human rights law. Whatever the answer may be on the customary law status of the Universal Declaration itself, given that the various specialized international human rights conventions have not all obtained universal acceptance, the Declaration remains the primary source of global human rights standards and exerts a moral, political, and legal influence far beyond the hopes of many of its drafters. I have referred just now to the other international human rights conventions that have been promulgated since 1948. These, of course, include the International Covenants on Civil and Political Rights and on Economic, Social, and Cultural Rights, which, together with the two optional protocols to the Political Covenant and the Universal Declaration itself, are commonly known as the International Bill of Rights. There are also, and importantly, Convention on Women's and Children's Rights, on the rights of migrant workers, refugees, displaced persons, and racial discrimination, and forced disappearance, prevention of torture, and other human rights. That the Universal Declaration opens the way for this proliferation of human rights-focused treaties that deepened and strengthened our understanding of human rights and the legal framework supporting these rights is undeniable. But the Universal Declaration did not simply give rise to a new body of international law. Together with the Charter of the United Nations, it also heralded a seismic shift in international law and in international relations more generally. What do I mean by that? Underlying the post-war generation of legal instrument was a set of new ideas. The belief that certain rights vest not in the states, but in individuals. The recognition that states must not simply refrain from taking certain actions against individuals, but have also affirmative duties to provide for individuals' basic needs. And the conviction that what the state does to its own citizens and to those within its jurisdiction is not just the concern of that state, but the legitimate concern of the whole world. These ideas were revolutionary because they put individuals and individual rights at the very center of international law. The changes brought by this revolution are evident in more than just the human rights instruments to which I have just referred. The impact can also be found in other bodies of law, notably in the law of war or international humanitarian law, where the adoption of the Geneva Conventions of 1949 marked a movement away from a system based on state-to-state reciprocity and towards a framework of individual rights. Common Article 1 of the Geneva Conventions epitomizes this denial of reciprocity with its analog to the prerogative of all states to invoke obligations erga omnes against states that violate fundamental human rights. And Common Article 3 of the Geneva Conventions, by means of which the Geneva Conventions address internal rather than international armed conflicts, represents the first time that in an international treaty that humanitarian law has been called upon to address internal armed conflicts and impose provisions that by many accounts constitute pure human rights principles. Of course, alongside the rise of human rights and the rights-based discourse, there has also been an ever-increasing focus on the need for respect for and enforcement of the rights concerned and the basic principles of humanity underlying them. It was this sustained focus on accountability, driven in great part by the unflagging advocacy of human rights groups that helped to bring about the establishment in early 90s of the first International Criminal Court since the Second World War. And it is to these courts and the impact on these courts of the human rights revolution to which the Universal Declaration gave rise that I shall now turn. It was in May 1993, faced with reports of terrible atrocities being committed in conflicts raging across the former Yugoslavia, that the UN Security Council, under Chapter 7 powers, established the International Criminal Tribunal for the former Yugoslavia, or ICTY. A year later, in the wake of the horrific events of Rwandan genocide, the Council would establish a second court, the International Criminal Tribunal for Rwanda, or ICTR. These steps opened the way for the creation of a number of other courts in the years that would follow, both international, such as the International Criminal Court, and hybrid, involving an amalgam of international and national attributes. As a judge since 2001, and most familiar with the work of the ICTY and the ICTR, they shall be the focus of my remarks this evening. I should underscore that neither of these two pioneering tribunals was established as a human rights court. Rather, they were both mandated to try individuals accused of serious violations of international humanitarian law, as the law of war is now commonly called. Nor were these the first international courts to have sought to try individuals accused of war crimes, crimes against humanity, and other such egregious acts. Famously, the International Military Tribunal in Nuremberg and Tokyo, established after the Second World War, were mandated to do just that. Though these courts were also in many respects not truly international, as they were founded by the war's victors. By comparison, the ICTY and the ICTR, often referred to as ad hoc tribunals, were created by the UN Security Council on behalf of the United Nations as a whole. Though they may not have been the first courts to try individuals for violations of international law at the international level, the ICTY and the ICTR did mark the first concerted effort in this regard since the aftermath of the Second World War. Indeed, in the nearly 50 years that lapsed between the trials in Nuremberg and Tokyo and the creation of the ICTY, efforts to ensure accountability for mass atrocities in any courts, whether national or international, were all but non-existent. The ad hoc tribunals were also, and importantly, the first international criminal tribunals to be established at the international level since, and in many ways arguably because, the human rights of the human rights revolution to which I have just referred. Indeed, although the only explicit reference to human rights in their statutes concerned the need to give due account in the composition of the chambers to the judges' qualifications, that is, their knowledge of various bodies of law, I would argue that human rights law, the body of law to which the Universal Declaration gave rise, was central to their work and to achievement of their mandates. What do I mean by that? First, and most simply, strict adherence to human rights standards was vital to the ad hoc tribunals' legitimacy and authority. Justice, in the truest sense of the word, is not possible without fundamental fairness. While the Nuremberg Tribunal may have been able to operate with relatively minimalist procedural guarantees, it would have been unthinkable for a court established by the United Nations some 50 years after the Universal Declaration to operate without respecting the full panoply of fair trial rights and due process guarantees stated in the Universal Declaration and further articulated in the political covenant. Perceptions of the legitimacy and authority of the tribunals were fragile enough during the early stages of their work for other reasons, had they not rigorously applied and scrupulously adhered to the highest human rights principles. I have no doubt that their work would not have gained the respect that it has. Given this, it is not surprising that the influence of human rights is palpable in both the statutes of the ICTY and the statute of the ICTR, even if not defined expressly therein as a source of law. Notably, in the lead up to the establishment of the ICTY, the United Nations Secretary General explicitly indicated that the new tribunal should take into account international human rights law when it came to fair trial guarantees, stating that it is axiomatic that the International Tribunal must fully respect international recognized standards regarding the rights of the accused at all stages of the proceedings, as contained in Article 14 of the Political Covenant. The language of Article 21 of ICTY statute and Article 20 of ICTR statute both track the language of Article 14 of the Political Covenant in many respects. The influence of international human rights law is evident in other provisions of the statutes as well, from the acknowledgement of the availability of appeal and review, provisions not present in Nuremberg, notably to the express provisions of avenues for pardon and commutation of sentences. But that is not all. Importantly, in extensive rules of procedure and evidence elaborated by the judges in the early days of each tribunal and frequently amended thereafter, the core guarantees in the statutes of the ICTY and the ICTR were elaborated upon and transformed into specific procedures. This was no easy process, and it involved synthesizing practices drawn from different legal traditions of the judges and their interpretations of the fair trial standards at issue. The judges had to devise procedures that would be viable without any police force to enforce rulings, and had to develop rules for the admission and treatment of evidence more generally. They had to develop mechanisms to protect victims and witnesses, while balancing such protections with the desirability of having public court hearings. They had to devise rules governing defense counsel, who, unlike prosecution counsel, were not staff of the tribunals themselves, and to provide for a legal aid system. And the judges had to address issues as administrative as official languages and translations, and as fundamental as judicial impartiality and disqualification. As I hope this list suggests, there are a great many components of the tribunal's rules that turn on or implicate human rights considerations and go well beyond the guidance given by the Universal Declaration or Article 14 of the Political Covenant. Not surprisingly, the statutory provisions to which I have just referred and the dozens of rules of procedure and evidence developed to guide the proceedings and uphold fair trial guarantees gave rise to hundreds, if not thousands, of rulings demonstrating again the centrality of human rights to the tribunal's functioning. At the same time, myriad procedural questions were raised over the years to which the statutes and the rules of the two tribunals did not offer explicit answers. Time and again, the judges looked to human rights principles and precedents to answer these questions. Thus, for instance, in a 2001 appeal judgment, the ICTY was called to consider what inferences could be drawn from the decision of an accused person not to testify. While the ICTY statute made plain, in line with the Political Covenant, that an accused may not be compelled to testify against himself, neither the statute nor the rules explicitly identified the consequences of a failure to testify. Unlike the corresponding provision in the Rome Statute of the International Criminal Court, the appeals chamber in that case drew upon the reasoning of the European Court of Human Rights to conclude that in the absence of express statutory safeguards and warnings, an accused's silence could not be considered in the determination of guilt, which is, I note, the same approach followed by the International Criminal Court. Other examples abound. In one appeal judgment, the ICTY was guided by the European Court's jurisprudence concerning the right to a reasoned opinion. And in a 2007 decision, the ICTY turned to the European Court precedents in relation to questions of admissibility and evaluation of evidence. The ICTR similarly had occasion to refer to the jurisprudence of the European Court, as well as that of the United Nations Human Rights Committee, including in construing the right of an accused to be informed promptly of the reasons for his or her arrest and the nature of the charges brought against him or her. In one case, the ICTR Appeals Chamber was also called upon to address questions regarding the circumstances in which a court may insist that the defendant is represented by counsel. Questions that, when raised in the ICTY in the case of Slobodan Milosevic, led to lengthy considerations of the jurisprudence of the Human Rights Committee and of whether the right of an accused to self-representation may have to yield to the overarching right to a fair trial in certain circumstances. In ruling on that question, the ICTY Appeals Chamber adopted the basic proportionality principle employed in human rights jurisprudence in holding that the restrictions on Milosevic's right to self-representation should be limited to the minimum extent necessary to protect the tribunal's interest in assuring a reasonably expeditious trial. In dealing with certain issues, tribunals are sometimes engaged in a balancing exercise, interpreting provisions of instruments such as the Political Covenant or the Universal Declaration in the context of the respective tribunal's object, purpose, and unique characteristics when weighing questions such as witness protection versus a defendant's right to face his or her accuser or the right to provisional release pending or during trial. There is, unlike the statutes of the ad hoc tribunals, the Rome Statute of the ICC, adopted several years later, explicitly provides in Article 21 that the application and the interpretation of the sources of the court's applicable law must be consistent with internationally recognized human rights. It is undeniable, however, that human rights principles were central to the development also of the tribunal's extraordinary corpus of procedural jurisprudence. Human rights law, likewise, played a vital role in the context of the tribunal's substantive jurisprudence. That is to say, the tribunal's rulings addressing the crimes under their jurisdiction. Time and again, the tribunals looked to human rights law and legal precedents for evidence of customary international law, so as to ensure that the principle of legality was fully respected, and for guidance in interpreting the somewhat skeletal provisions of the statutes. For instance, in one case, the trial chamber considered the components of the crime of arbitrary imprisonment as a crime against humanity and expressly relied on human rights as set forth in the Universal Declaration, the Political Covenant, and the Inter-American Convention in addressing this question. In another case, The ICTY once again relied on human rights law to reach a definition of inhuman treatment as a grave breach of the Geneva Conventions. Notably, the definition eventually distilled tracked the approach of human rights jurisprudence by defining inhuman treatment in relative terms. That is, as an act or omission that deliberately causes mental or physical suffering, but falls short of the severe mental and physical suffering required for the offense of torture. In a number of other cases, the chambers were called upon to address what constitutes the crime of persecutions on political, racial, and religious grounds as crimes against humanity. An ICT trial chamber looked to the Universal Declaration and the two covenants and concluded that it was possible to identify a set of fundamental rights, the gross infringement of which may amount to a crime against humanity. In other cases, chambers likewise concluded that the discriminatory denial of classic political, social, or economic rights, such as the right to employment, the right to freedom of movement, to proper judicial process, and to proper medical care, can, in certain circumstances, rise to the level of the crime of persecution. The treatment by the tribunals of the crime of rape offers another important example. The ICTR's first case, the Kayesu case, was groundbreaking in many ways, not least because it was the first case ever at the international level to rule that rape and crimes of sexual violence could, in certain circumstances, constitute the crime of genocide. The Akayesu chamber, as well as a number of trial chambers of the ICTY in the years that followed, would draw upon human rights precedents and norms, such as those concerning human dignity and physical and moral integrity, to construe and clarify the elements of the crime of rape in the context of different international crimes, and basing the crime of rape on coercive circumstances, rendering consent impossible. In doing so, the trial chambers, as had so many other chambers at both tribunals, were relying in part on human rights norms to interpret and lend greater specificity to the prohibitions contained in international humanitarian law. Without such specificity, when it comes to the elements of crimes, and without the ability to root their work in core principles of international law in this manner, the work of the pioneering international criminal tribunals would not have been possible. I have been speaking thus far about the impact of human rights on international criminal tribunals. Before concluding, I would like to touch briefly upon the impact of these tribunals on human rights and the development of international law more generally. As the examples I've just given suggest, over the more than 2 decades of their existence, the tribunals, while not human rights courts themselves, produced an extraordinary body of jurisprudence interpreting and applying a wide array of human rights norms. In doing so, the tribunals not only made it possible to carry out their own mandates in a principled manner and demonstrated in no uncertain terms the continued significance of many of the rights articulated in the Universal Declaration. They also made remarkable contributions to the development of human rights, providing courts in other jurisdictions with valuable precedents demonstrating how human rights principles may be applied in practice. The tribunal's contributions are particularly notable given that existing human rights courts and bodies have exclusively civil jurisdiction and may not be called upon to directly resolve the full panoply of matters that a criminal court adjudicates. Indeed, through the application of provisions such as Common Article 3 of the Geneva Conventions and the exercise of jurisdiction over crimes against humanity, the ICTY and the ICTR, while not human rights courts themselves, have in many ways enforced quintessential human rights. In doing so, they have addressed, if only to a small extent, gaps in the competence and enforcement capability of regional human rights courts, and made all the more evident the extraordinary synergy between human rights and international criminal justice. In addition, through their nuanced jurisprudential discussion of substantive issues involving both human rights and international humanitarian law, the ICTY and the ICTR contributed to a growing convergence in the applicability of these two fields, with the principle of humanity serving as the common denominator. Through this convergence, many of the gaps in the application once thought to exist between these two bodies of law have been reduced or eliminated, broadening the scope of humanitarian protections and the rights-based legal framework, and thus advancing key aims underlying the Universal Declaration. Let me offer one final example in this regard, this time concerning the crime of torture as a crime against humanity. While torture is universally condemned and prohibited, international humanitarian law does not provide a definition of torture. Accordingly, the trial chambers in the ICTY's Kunarak et alia case turned to human rights instruments and jurisprudence to determine when an act, in this case the act of rape, constitutes torture in the context of international humanitarian law. The appeals chamber in this case considered that rape causes severe pain and suffering, whether physical or mental, and thus justified its characterization of rape as an act of torture. The appeal chamber thus relieved the prosecution from establishing that particular levels of pain were suffered by the victims and from the need to prove this by bringing, for example, medical evidence to the court. Notably, while the trial chamber began by considering the definition of torture provided in the UN Convention Against Torture, it went on to hold that this definition was not, I repeat, not, reflective of customary international humanitarian law, because it required, as one of its elements, that the act at issue be committed by or at the instigation of a public official. The trial chamber reasoned that this element was a result of the context in which the Torture Convention operates, with states as respondents, and is therefore directed only to states' obligations. However, the trial chamber concluded that for ICTY purposes, the involvement of state does not modify or limit the guilt or responsibility of the individual who carried out the crimes in question. On that basis, the trial chamber held that the involvement of a state official is not necessary for an act to be regarded as torture under international humanitarian and, I may add, international criminal law. In affirming this ruling, the appeals chamber took pains to make clear that while the definition of the crime of torture, as set out in the Torture Convention, may be considered to reflect customary international law as far as the obligations of states are concerned, this does not mean that the definition of the crime of torture set forth in the Torture Convention wholly reflects customary international law regarding the meaning of the crime of torture and for purposes of international criminal prosecutions. This is just another example of the impact of the tribunals on the development of human rights and of how, through their work, criminal tribunals enhance the protective character of bodies of law that, though remain distinct with different scopes of application, are reflective of common principles rooted in the Universal Declaration that we celebrate here. Clearly, the struggle continues. Of course, here in the United Kingdom and in the communities and countries the world over to ensure that human rights are respected as we go about our daily lives. Yet, I hope my remarks have illustrated that we should not ignore the extraordinary impact and significance of broader efforts to uphold human rights at the international level, including the impact and significance of the work of international criminal tribunals. These tribunals, while established outside of the field of human rights, have nonetheless made unparalleled contributions to the understanding of human rights, to the promotion of these same rights, and the norms underlying them, and crucially, to our ability to enforce these rights when they are violated, whether in our own communities or on the other side of the world. Indeed, we cannot and must not ignore the contributions of these courts. Rather, they are something to be celebrated, just as we celebrate the extraordinary Universal Declaration itself. And I thank you.
Thank you very much for that interesting and illuminating talk. I'm very interested in whether you think these international courts and tribunals were set up in the face of the breakdown of the rule of law in states that had failed. As those states or the successor states started to have legal systems of their own in place again, do you think the way that the international courts had interpreted a law had an impact on the way they then interpreted their own law? Or do you think this carries over into an international law as well, the reciprocity between...
I certainly would hope so. I think it often happens that we in international courts pave the way for new interpretations of criminal norms, which then are hopefully sooner or later taken up in national jurisdictions. Take, for instance, something which is one of the greatest, most grievous crimes which continues to be committed so frequently, the crime of rape. In the Kunara case, in the Furunzia, in Nakayasu, we have established a set of norms which simplifies the evidentiary issues for prosecutors everywhere in trying to establish that the crime of rape has been committed. We have provided fairly simple yet significant definitions of rape. We have focused the whole approach to rape on not the actual use of physical force or coercive force, but on coercive circumstances in which almost by definition the very notion of consent does not apply. And there was, as you know, a major summit in London a few years ago about sexual violence. And I saw as one of the participants in that conference how the norms that we have been articulating in international criminal tribunals have affected the tenor of the discussion by international experts. So I see some kind of a synergy in which international criminal tribunals will have a pioneering role in suggesting new approaches, new definitions, new techniques. But these would really have only real significance for real life if they are followed by national jurisdiction. I think the future of international crimes or prosecution, the future of accountability, lies not in international criminal courts. We are so few. Our resources are very limited. Our budget does not compare with the budgets of national courts. The future will depend on whether states are willing to carry the torch by prosecuting war crimes, by applying more robustly the principle of universality of jurisdiction, which often allows states, in fact, to prosecute crimes without any nexus with either the state which would prosecute or the citizens of that state.
One of the things that international human rights law has started to do is to, especially in relation to sexual violence and gender-based violence, is to put responsibility onto states for failing to protect people from the sort of circumstances that you were describing that effectively amount to coercive circumstances, or failing to put in place the kinds of systems that enable women to feel safe. That, when you come to criminal courts, that clashes with the presumption of individual innocence. How in your criminal courts did you go about that using international human rights norms?
Well, of course, states could have prevented many of those offenses from occurring in the first place. And they have the overarching duty, whenever they have jurisdiction, to follow up by prosecuting. But the mandate of international criminal tribunals is, like of all courts, a limited mandate. We decide the cases only by one criterion, whether the law and the evidence suggest a conviction or an acquittal. We are not guided by extraneous agendas. We are sometimes accused of not having done enough to promote reconciliation. But while the United Nations Security Council in various resolutions pertaining to international criminal jurisdictions speaks very favorably of the goal, salutary goal of reconciliation, they never gave us the mandate to decide our cases by whether an acquittal or a conviction will promote or discourage reconciliation. Reconciliation is up to national communities, to intellectual leaders, to religious leaders. International criminal courts have and should have a limited mandate. Imagine for a moment that we would convert ourselves to the very important and effective South African Commission on Truth and Reconciliation. Would you want us to decide a case and convict somebody because we would feel that conviction in this case would favor reconciliation? I think we would, in fact, not be faithful to our mandate as judges. We operate in a very, very political context. The decisions we made on conviction in most cases, but sometimes on acquittal, are practically always criticized by someone. And you get used to it. You never take those criticisms lightly. I felt that one thing which I did not develop adequately as a judge, or especially not as a president of courts, was to develop thicker skin. I take those criticisms very, very seriously, but there's nothing that you can do about it, and you only hope that over time people will recognize that we must be faithful to our mission. Judicial mission, judicial conscience, only judicial considerations, no external agendas, no political agendas, no yielding to pressure, maintenance of judicial independence, and so on.
I suppose that's, you may be sort of hinting at this political, standing away from the political issue, but one of the things that people sometimes say about international criminal courts is that they get the little fish, the people on the ground, but the controlling minds, the people who may have conspired or encouraged or incited some of these offences, get away because they can be kept at one remove. I mean, does international human rights law help with thinking about that?
I think that the proposition is only partly true. In the ICTR, we prosecuted and convicted quite a few cabinet ministers. In the ICTY, Slobodan Milosevic is only one, Karadzic, General Mladic, Stanislav Simatovic, this case is now being tried on remand, where heads of security service, this is not small fish. Nevertheless, I recognize that if you look broadly at the international scene and national jurisdictions, presidents and prime ministers are rather seldom prosecuted. It is the smaller fish, not necessarily really small fish, but say intermediate officials. In international criminal courts, we have been doing quite well. And the ICC has tried to prosecute some very prominent people.
Yeah.
So we are not doing that badly.
No. I was putting a case to you. I'm going to let other people do it. Does anyone here want to ask any questions of Judge Meron? Must be a question somewhere. Yes.
Thank you very much for the talk. On a human level, and you began to just hint at that in your last answer, on a human level, how did that group of people very involved in establishing the ICC and also in being the judiciary, how, while you were learning how to operate, how did that affect you and your colleagues on a human level?
Well, first of all, I think that we demonstrated considerable unity in, for example, agreeing about the rules of procedure, which we had to adopt. We started in a way from a very Anglo-Saxon system and with regard to procedure, and we still followed that, but with regard to evidence, we over time shifted and follow, I would say, more the civil law system on evidence than Anglo-Saxon principles. But very often, I mean, perhaps more often than I would have liked, but this is quite natural, judges, they are human beings, and they come with their approaches and traditions and so on. And we had some very, very serious differences about substantive decisions. And these controversies were extremely painful because judges do take their work very, very seriously. There were some acquittals which were, on which we had a major split of judges, between judges, which for a while affected their relations. In the case of Perisic, we had a majority in appeals of 4-1. It was an acquittal. In the acquittal of Gotovina, we had a smaller majority of 3-2. And the Gotovina case in particular left for a year or two clouded relations between judges. Eventually that was laid to rest, not by us, I have to admit, but by the International Court of Justice, the principal judicial organ of the United Nations, which in a genocide case between Serbia and Croatia was forced by an argument of a council to look at our some major decisions that we have made, including Gotovina, and expressed a unanimous support for the majority decision. Being a judge, and this is perhaps not often realized generally, is something which it's an exceptionally solitary profession, in which you can talk about your small or large agonies to practically no one, perhaps to your own spouse, to your law clerks, but to nobody, no one else. I became a judge after a quarter of a century of professorship of law at New York University, and I had to change all my instincts. Previously as an academic, we look all over the place. we resort to analogies. We show our erudition by citing A and B and C and D, the more the better. As a judge, we are not, you don't have those luxuries. You have to have a sort of a laser type focus on the evidence and the law before you. And the decisions that you make are extremely, extremely difficult at times. It's not a job which you, where you go home in the evening, you say, now I'm going with a clear home, clear head, and could enjoy the family or the television or whatever it is. No, those decisions affect human relations. I'm glad to say that over the years, we managed to overcome them. And most of the judges, all of the judges, I would say, are really on friendly terms, and we forget those controversies, sometimes harsh language, which is unavoidable, at least between ourselves, or sometimes in a dissenting opinion, which is public. C'est la vie.
Yes.
Thank you very much for your talk this evening. I want to ask you about, prior to the Universal Declaration, what moments in international history may ultimately have impacted their development. And in particular, I have in mind at the time of the League of Nations.
Could you speak louder, please?
Thank you. I'm thinking about precursors that may have influenced the development of the Universal Declaration. And I have in mind, for example, the minority treaties that followed the peace settlement of World War I that were put into the hands of the League of Nations to guarantee, or the mandate system, for example, within the League of Nations that created a sacred trust on the part of the League of Nations to guarantee the rights of what were called native peoples at the time. And in particular, within both of those systems, there was petitioning where, within the minorities treaties, individuals and groups, minorities, had, some would argue, a measure of legal international personality through the minorities treaties, and at least within the mandate system, some political form of international personality, and that right to petition the League in terms of violations of their human rights. Do you see any legacies? That's just one example, but others perhaps that, apart from the atrocities of World War I, World War II, which are obviously considerable, may have generated the revolution that was the Declaration?
Thank you. This is a very good question. Perhaps I would add to your catalogue of influential doctrines the law pertaining to protection of rights of aliens in other countries, which in the 19th century is adopted or incorporated as sort of a code of, they called it, it would not be politically correct to use this word today, civilized norms pertaining to justice and so on. This developed in purely technically in a sort of reciprocal base, a French citizen being mistreated in country X or Y, and in the discussion which would follow between the two governments, things which are very similar to some of the arguments you would use today in human rights would come up. But no, I completely agree, minority treaties, the right of petition, the mandate system, were very influential in a way in sort of paving the way to the adoption of the Universal Declaration and various UN human rights instruments. At the same time, there was a gap there, and the gap was the Second World War. It really proved how all those instruments, which in the normative sense should have guided the conduct of the belligerent states, were completely insignificant, in which you saw the most barbarous acts that you could consider, in which the Geneva Conventions, especially on the Eastern Front, was totally ignored. So while all those instruments that you have mentioned, and one could perhaps mention more, had a very salutary impact on drafting of the Universal Declaration, in a way, because of the events of Second World War, we had to start almost anew. And I mentioned the fact that the Universal Declaration mentions, I think on 13 occasions, for a very short document, the principle of equality. And this was caused directly by terrible treatment of Jews or Gypsies by the Nazi regime during the Second World War. So in that sense, we almost had to start de novo in drafting documents that would take into account the reality of life, the discrimination, racial discrimination, religious discrimination, the colonial rules, and elaborate and articulate the principles which became the cardinal principles of those UN instruments: universal jurisdiction, the political covenant, the economic covenant, and so on.
Any more? Or should we go and have a drink in the SCO? Oh yes, there's one here. Thank you. If you just wait for the microphone, please. Thank you.
Thank you. Earlier you mentioned that you don't see the role of international criminal tribunals as being to deliver reconciliation to communities.
Could you speak louder, please?
Sure. I wonder if you might speak a bit to the idea of restorative justice, and one of the charges having been leveled against the International Criminal Tribunals being that they're too far removed from survivors, from victims' families, and that it doesn't provide a sense of justice sometimes to people who were on the ground during atrocities. Is there a way, in your view, that international courts can or should try to bring justice closer to victims' families and survivors?
Thank you very much. I think all of us would agree that holding international criminal trials in the countries where the atrocities were committed would be a very good thing. It would be great if we could hold trials such as those in which, or appeals in which I was involved, very close to the place of where the victims live, where people experienced some of those terrible events, which later came to us in the form of judicial prosecutions. But very often this is not possible. Don't forget the tribunal was, for instance, ICTY was established in 1993. The conflict in Yugoslavia started in 1991, and it was only in 1995 that the Dayton Agreement was concluded. You could not have an international court with witnesses who would not be intimidated coming forward to testify 20 miles from the front line. Now, here the solution was to establish the tribunals in different countries. In the case of the ICTR was established very quickly after the genocide, and the situation in Rwanda was somewhat problematic. In the case of Rwanda, there were additional concerns because in the beginning, Rwanda was still favoring capital punishment, which we, as a United Nations court, cannot accept. I am so sorry I did not recognize here, I did not see you, Kate, the director of the Bonavera Institute, which has greatly helped to make this event this evening possible. Yes, this is something that we favor. It is not always possible. I think that perhaps in the future, I would be inclined to have a more positive approach to a sort of dual roles. an international criminal court which in most cases at least close during the duration of the conflict and perhaps for some years after that might have to function outside of the country, but provided that we take care not to contaminate evidence, I think the South African model of Truth and Reconciliation Commission should be resorted more often. And while we would not be able as judges to contribute directly, only indirectly, to reconciliation, that those other bodies could at the same time work on reconciliation. One of the problems of international criminal justice is that we work with different and conflicted stakeholders. Some people tell us your mission is to establish truth about what had happened. Well, I think that our judgments, our proceedings, and so on, make a great contribution to a narrative of truth. But is the establishment of truth per se a mission of international criminal courts? We try to contribute to that. For example, when we have a guilty plea, we would accept or consider seriously accepting a guilty plea only in a case where the person pleading guilty would be willing to give the court a truthful statement of his recollection of the events which led to the prosecutions. People tell us, well, your primary role would be to meet the expectations of the victims. Now, my sympathy is with the victims, the sympathy of all of us. But as judges, if we were unduly guided by that consideration, normally you would have to typically be prejudiced towards convictions. And we must be objective on that. I think that the credibility of international criminal justice would collapse if we would be suspected of any one particular agenda. So these are tough propositions in which I have reached the conclusion that we cannot satisfy everybody. So in the long run, I think that our job will be well done if we satisfy our judicial conscience. The fact that we adhere to legal principles, that we go by law and evidence, and that's it. We cannot accomplish everything, or we would not be courts of law.
I wondered, I don't put you on the spot, Kate, but we do have Kate O'Regan, who's the head of the Bonavera Institute here, and was a South African Constitutional Court judge. And I wonder if you have any views on whether in post-conflict situations a truth and reconciliation approach is an alternative to a criminal law approach, or whether you can run those side by side, or could run those side by side in particular contexts.
Well, thank you, and thanks, Ted, for a fascinating lecture. Of course, the South African model was actually linked to amnesty. So if you told the truth about the crimes that you'd been engaged upon and the full truth, you would then be eligible for amnesty. So in some ways, that's the exact reverse of a kind of a criminal process. It doesn't have, it's not the only way that you can design a truth and reconciliation process. So I don't think amnesty is necessarily a component of it. But I do think what was important, and it links into something that Ted said, which is that reconciliation can't really be built on a deep disagreement about the facts. And it's enormously valuable to have criminal trials not only in relation to the sort of retributive processes that criminal punishment often represents, but also to get an independent body to determine the facts. And I do think that was very valuable in South Africa. It's very difficult for people to deny that the apartheid state was involved in, murder of opponents. and so on, because that all came out in a long process in the Truth and Reconciliation Commission and was established, I think, on the facts. So getting the facts is often the starting point to reconciliation.
Thank you. Right. Well, thank you very much for a very interesting talk, very appropriate to have here at Mansfield and also linked with the Bonavero Institute. So thank you. And thank you all for coming. Next Friday's, yes, it is next Friday. Yes, it is next Friday. There's 1 week missing this term. But next Friday's talk, we have Hilary Sperling talking about radical help and her ideas about how you might reconstruct the welfare state to enable people to empower themselves with help from the state rather than a needs-based approach. It's very interesting. It's a radical approach. So I hope that you will all come and hear that same time next week. Thank you very much.
Thank you.